Dr. Tilesch, would like to have you on stage. And let me invite, it's going to be the three of us this time. So, yes, let me invite on stage Mr. Levente Juhász, Government Affairs and Public Policy Manager on CE level at Google.
Thank you.
Let me introduce Mr. Juhász a little deeper. He leads on the topics of digital transformation, economic contribution, and sustainability on Google's public policy team for Central and Eastern Europe, and is responsible for government affairs for Hungary, Lithuania, and Latvia. For disclosure, for the audience, I have to tell that we've had heated discussions from Google's side and from the side of the person who knows comparatively what's going on in the world when it comes to regulation. So I think it's time to hear your reaction to what has been said now.
Well, thank you very much, and thank you very much for the introduction. I think this debate literally couldn't have been more timely, not only because of the importance of AI or large language models that have really captured so many people's and organizations' imagination this year, but literally I think the third or fourth trialogues of the AI Act are happening today and tomorrow. I'm not sure whether in Brussels or Strasbourg, but those decisions are really made now that you were alluding to. I found myself in agreement with most of the things we've said as far as the principles that need to be followed, but perhaps just the sort of technical observation that the AI Act will be directly applicable in member states, and our hope certainly is to have a consistent, harmonized framework across the EU. But we have said from the very beginning that AI is, in fact, I think our CEO has taken to the Financial Times to make the point that AI is too important not to regulate and too important not to regulate well. So what does that mean with regards to the AI Act? Our quick sort of pitch has always been that we have supported this risk-based pyramid approach. We think it's a really good framework, but as you just said, not only implementation, but the devil lies in the details. So what we stress usually from a high level, and I'm not an AI expert per se, but that the AI Act should retain, sorry, sometimes you can hear me, sometimes you don't, should retain this risk-based and proportional nature. And it should sort of assign responsibility at the right place in the AI value chain. Because the developers of AI systems are not necessarily the same organizations who deploy or provide those systems. And again, different organizations on the value chain may or may not have the information about where that technology ends up in terms of its application. Second, it should avoid, and again you've talked about this, inconsistency or conflict with existing and quite fresh body of EU law. Three quick examples come to mind. One is the Digital Services Act. I think many people in the room are intimately familiar because the co-organizer of this conference is the appointed regulator under the DSA for Hungary. And for example, one of the ideas now flying around in the parliament that recommender systems, YouTube's recommendation engine, should be a high-risk AI technology. We don't necessarily think that would add a lot to what the DSA has already brought to the table as a result of those are really intense negotiations. I think our discussion yesterday was animated at the best and certainly not antagonistic. So it should avoid contradictory legislative guidance for what you call this implementees or regulatees. Overlaps, I think, to an extent are okay, but when those guidances directly contradict one another, that's when the lawyers and the product councils and generally the large legal teams in organizations such as ours need a lot of help. And third, it should support international alignment of these norms. The AI Act should support international alignment of what hopefully would be a global governance for AI. because the Brussels effect is real. We have seen that in the world of privacy. And we really hope that Europe would strike this balance that we always think about in very abstract terms between enabling the innovation potential of AI, but also, safeguarding against those harms that may come from this technology if abused by bad actors, especially. So that's the short of it. I don't know how long that was. Thank you.
But to sum it up, Olivia, please help us understand how practically make this not to become an omnibus law, not to inflate its value, and achieve the golden rule of less is more.
That's my favorite sentence in policymaking, less is more. So, yes, and I could really just reiterate what I've already said. Coordination is really everything. There is a lot of talk about interoperability, but to make it so is easier said than done. And that is actually why this conference is a really good idea, I think, because we are bringing together different stakeholders here. So regulators, also regulatees, big firms, and I'm sure that there are smaller firms also represented here. And we need, so this know-how, the knowledge about how AI is best regulated is dispersed, because firms are the ones that are actually working with these systems. They are the ones who are facing the problems in everyday situations. Often the sort of problems that regulators, again, are not aware of. So yes, in regulatory jargon, I could say modern regulation and better regulatory agendas and these sorts of things that will be familiar words for regulators. But it's really all about consulting all stakeholders, not because we want to be kind or something, no, because we as regulators simply don't have the expertise or the resources to do it ourselves. And of course, we also want to be kind. But yeah, so if we have all these parties at the table, then there is a chance to get into discussions whereby firms can give us really valuable insights. And another thing that I often hear is people say, well, self-regulation is kind of an evil because, well, companies are doing it and companies are following their own interests and shareholder interest, and that is not in line with public interest. And there is some truth in it, but again, they have some very serious know-how, and if we join forces with regulators, then we can channel all that know-how. We can take over what is actually in line with our regulatory purposes, which hopefully serve optimal social interests, however those are defined. And so we have a hell of a lot better chance of coming up with some really good and sustainable regulation if we work together compared to when we are not.
Just referring back to the first session and what Imre Bart said on stage, I think that, when we think about what companies want and do around the upcoming regulatory wave, is such as AI itself is a double-edged sword. It's a double-edged type of an activity. And I think that it's primarily very much beneficial if big technology platforms are transferring their best practices, what they have developed way before this regulatory wave for their internal purposes, just to ensure that customers get proper care and there is no backlash in any parts of the world against their AI products and services. And of course there is lobbying. I mean, lobbying is quite a natural and accepted type of an activity, but I wouldn't equate the two. Therefore, what Google is saying in many respects, I've been happy to be part of a policy briefing about a week ago about the AI Act, is very much valid, because legislators on their own usually do not go as deeply in the technology and the deployment aspects of these products as they should. And there were lots of use cases that have been brought up by your policy team that just simply shows the sheer nuanced nature of how can you deal, in one fell swoop with the complexity of foundational models and multimodal systems that need, for example, different levels of risk assessment. That's by the way, one of the key hairy issues, I think, in the EU AI Act. So that's just one comment, but I think that I would like to ask Olivia, because she was talking about standardization, and standardization is something that is quite remote for most people. Like, if you're not on the inside of these standardization bodies, you don't have a lot of ideas on what's going on in there. So I would love to ask you to elaborate a little bit more on that. And here is why I think it's very important. The AI Act, and I think many of the upcoming regulations will be referring to a lot of standards that are in the making. So basically regulators are outsourcing some of the job on these standardization bodies that Olivia and some of our colleagues are also represented at. So can you please elaborate a little bit more, because of the shortage of time, you didn't have a lot to talk about the standardization parts, but that kind of standardization work that you are involved in, and how should people in this room imagine how this standardization works, and what is the importance of it in the AI age?
Sure. Okay, so I'm pretty sure that many firms are familiar with like ISO standards, for instance. Okay, so if I'm talking about quality management, then those of you in the audience who are working in this area will think about ISO 9001. And I could throw around with numbers. So there are a lot of standards that you just know that you have to comply with, or else you are not competitive in your relevant sectors. And AI is going to be one of the next areas where these standards are going to be very important. So the ISO has a joint standardization committee on artificial intelligence with the IEC, and that's JTC1 and C42, and we have 5 different groups that are working in 5 different directions. I'm talking at least a 2-digit number, if not a 3-digit number of standards that are under development only in this area. Maybe, these 5 groups, maybe it's just a 2-digit number, but so it's an awful lot of standards. And each one of them is really detailed. And for the European standardization efforts, so that's going to be CEN and CENELAC, the 2 authorities that are going to be in charge of that. Some of you will be aware of the fact that the EU Commission has issued its draft request for standardization a couple of months ago, and these 2 agencies are tasked with developing the standards. There is also a significant collaboration between the international standardization bodies and the European standardization bodies, which is a good thing. Of course, there is a fair amount of politics involved. So again, your baby, my baby approaches are feasible, are possible and conceivable, but there is some collaboration, which is great. Another body that was on the slide, but I couldn't talk about, what is the IEEE. So that's a professional organization, and they have a slightly different role to play. Again, those of you who are using standards will know that sometimes you would opt for IEEE standards as opposed to ISO standards because they are coming from an engineering perspective. They often better align with actual product development processes compared to ISO standards. But when it comes to hardcore compliance questions, then the ISO standards are more like the Bible of standardization. So that's why whatever the ISO comes up with, that is going to be something that firms are going to look out for and will try to implement it. Another thing that is important in this respect is that, and I've heard comments like that, that the EU AI Act is, so some people say it's way too descriptive. Others say, oh my God, we are missing foundation models, we are missing this and that, and so we are, in last minute, we are adding everything we can. And then this less is more approach that we have talked about, while we are doing the exact opposite. And that is something that is very common in regulatory discussions, that we come up with a framework that works well, and then politics comes into the picture. And everybody would like to have certain interests secured. And, well, if you turn this into a formal logic exercise, which I won't do, but just in case you wanted to, then sometimes adding these specificities actually narrows down the scope of the laws as opposed to broadening them, which is actually the goal when we are doing this. So this is a very dangerous and sometimes almost always counterproductive exercise, actually. So the reason I'm saying all this is the AI Act is going to be a very robust horizontal regulation, I believe, but we should all be aware of the fact that this is still a very high-level regulation, actually the highest level regulation within the EU, meaning we don't want to stuff everything and anything into that act, okay? So that's just the highest level of regulation. In a next level, that is where standards come into the picture, we can get much more detailed. And that's what we should do, okay? So when we have this urge of, yeah, let's put this in and this in, resist that urge. Leave that to standardization. And this is also why it's really important to use the right terms, because when we sit down in standardization committees and start to develop these standards, and when it comes to EU standardization, much is already done in the ISO, so then we probably don't want to do something totally different. Then if there is inconsistency between terms, then that makes our work that much harder. And there is a reason why standardization activities take a couple of years to come out. And so if because the processes are incredibly complicated and there are a lot of discussions and stuff, but if we make our lives even harder with these inconsistencies, that is not going to help anybody. And if it had been alluded to that in AI there are like weekly cycles or a couple of bi-weekly, 6-weekly cycles of change, well, the regulation is kind of lagging behind all that with this 2, 3, 4, 5 yearly cycles.
Let's see Levente's reaction to that.
I just wanted to make the comment that you spoke about the allure of trying to fix everything with the AI Act and at that level. And as far as I know, the story of the AI Act is pretty much that it was tabled late last year, and then generative AI came, and it's how sort of upended the whole discussion. And indeed, one of the biggest risks that we have seen over the past few months is that foundational models or general purpose artificial intelligence models, and I'm not very familiar with the exact difference, were proposed to be pulled in to the high-risk category. And that's something that we really advised against, again, because those are just general-purpose models, may have a variety of applications from very low risk to high risk. So and
do not even mean the same thing, as Olivia pointed out. They are different things.
Yes, that's true. But we're focusing maybe on the framework, because the boundaries or the lines will be drawn in the sand. And we think really the trick is to define the boundaries of what is high risk properly. And again, if you pull general purpose technologies in there, then you'll lump a lot of things in there that ultimately don't belong there. Also, we're talking about
give us specific examples.
Yes, of course. Because this is a highly changing, emerging technology. This is a challenge of regulating in the abstract for policymakers, not an easy task. So, for example, one of the, again, proposals on the table is to define all biometrics-based technologies as high risk.
Right.
It's easy to sympathize with the intent. There's a lot of talk about surveillance, how that is applied in other jurisdictions. And I've seen that on the slide of Adrian earlier, we have ruled that technology out very early in the development of our AI journey, I think as early as in 2018. But when you use Google Photos or Apple Photos or whichever other provider, which will find, for example, just the right shot in your burst of your photos, or will identify the person who's smiling, or will identify the face of the person across your whole database of files, so that you can pull out all the photos from grandma, that's also a biometric-based application, or biometric technology, and clearly it's not high risk. So these are the small details that we think matter tremendously, so that Europe, again, gets the balance right and a principled, flexible, agile approach. And, you know, it's not just us. Often when public policy people from large tech companies speak about policies on stage is the point that it's not only about us that you regulate. You regulate an entire ecosystem. You regulate SMEs, and especially you regulate startups. I'm not sure, although I would hope that some startups or startup representatives would be in the room, but I recall a survey just from late last year. I pulled out the numbers, so that was about a year ago, that 50% of AI founders in Europe are concerned that the AI Act will slow down AI innovation in Europe. That was even before generative AI came in, and legislators and policymakers became much more focused on what should be crammed into the high-risk category than before. 16% of founders consider immediately relocating their development from Europe to another jurisdiction or stopping it here altogether. And that's, so you might argue that that is subjective. But again, last week, another conference, I've heard that of all the VC capital money sloshing around the world, maybe you can keep me honest there, George, 40% of all AI, VC, venture capital investment goes to China. Another 40% goes to the US. 7% ends up in Europe. And I think that's the problem that we're trying to tackle, largely speaking, with this piece of regulation. Create a harmonized framework across the EU that really allows large companies to provide and develop services. And I would just really like to point out that, again, this is not in the abstract. Google maintains a tremendously talented, small engineering team right here in Budapest, who are working on large language models right here in Budapest. So everything you've heard about talented Hungarian engineers working on exciting global stuff is true. They work on the enterprise version of our consumer-facing chatbot that's called Bard. And also great startups working out of Budapest, or you know, having research and development, or development operations here. That's largely true, I would argue, for Central and Eastern Europe at large. So what I would just wrap it all up is the concept of competitiveness, and how Europe and Central Eastern Europe and Hungary should really not miss the train due to an overly prescriptive piece of regulation.
May I comment on that? Because I agree with a lot of the things that you have said, but I'm also the devil's advocate here. I mean, that's what I'm playing. So yeah, so I would also add to those startup figures that you said that, and that's also pre-generative AI, that 60% of AI startups were not actually AI startups, but people posing as AI. That was another, I think, crucial startup issue. But by and large, I agree with a lot of that you said. And actually, I don't know if we should go into the startup, direction that much. I think a lot of the concerns are very valid that, companies like Google will afford compliance with the AI Act, and startups will find it much, much harder. But if we are focusing, and that's just a side comment, on the pure commercial value chain of like how you generate value and revenue from AI, it's obviously at least a three-tiered value chain where there's an infrastructure layer, a model layer, and an application layer. And most of the startups can only focus on the topmost layer, which, I mean, do the math, do the rest of the math. So I'm not particularly bullish about AI startups who are not outside the umbrella of Google's and Microsoft's. But that's just a personal opinion, and that can be debated, absolutely. Going back to the macro level, though, there was one aspect in Olivia's speech that I really wanted to address, and that's mostly because, I mean, when Olivia asked the question about engineers in the room, we saw that the situation is that we probably have a lot more lawyers in the room than engineers. And this is one thing that I kept hearing consistently in Silicon Valley, especially during the times when the AI Act was not named AI Act yet, but everybody knew from 2019 on that there is something moving in Brussels, and there's a high-level expert group, and wise people have congregated to flesh out something that will look like regulation one day. And I've been part of a lot of like these early AI policy conversations, both in the US and the EU, where engineering leaders from big companies and mid-sized companies as well, they said, we are not invited to these conversations. And when people are discussing AI policy, they are only inviting the lawyers. And because of that conversation, even if had they been invited, they would be bored to tears. And the other way around, when a lawyer enters, you know, a technical conversation. So question to you is like, do you see any effort on Google's behalf to meet that imperative that Olivia was talking about, like technical accuracy for implementation, for operationalization, or you're matching up policy people at the Commission with policy people on your side? So do you think it's worth doing, and is Google doing anything about infusing that type of engineering knowledge and asking for higher levels of specificity that would enhance operationalizing regulation?
So I think the coherent answer to that is that the policy-making pipeline is a long one with various stages. Where we are right now is that members of the European Parliament, such as his name evades me, Mr. Bonifay, who dialed in, he or his advisors might benefit from deep-level technical expertise, but that's not where the interest and the level of discussion is. Now, later down the road, when standards are being developed, I'm sure we will be there at different levels. But you have to meet the interest at the level where it is currently. But when we, for example, set up meetings between our executives, those are often technical people. And I think vice presidents and directors of engineering have been in Brussels every week for the past year. So as long as there's an opportunity to tell that story, I'm sure we are there, and we are part of that conversation.
That's great news. And Olivia, would you like to talk a little bit more about how we create that common language, because you're in the very fortunate position that you did multiple degrees to be able to bridge these words, but how can we all work on acting as bridges and not doing a PhD in 3 disciplines?
That's a good question. So the funny thing is that a discussion within a classroom where I teach about AI and a discussion within a high-level policy gremium when it comes to technically inclined terms is very similar. There are the technical people in one corner, everybody else in the other corner, and those two people don't speak the same language. And the problem is, while students they are stuck in my lessons for a couple of, like an hour or two, they have to be there, they have to go through that. In policy circles, people try to avoid these conversations because, well, I don't understand, I don't know, I didn't sign up for that, I'm not the technician, I'm a policymaker, and vice versa. So it's really hard to actually get into a real conversation. So we can sit down and pretend to listen to each other. I say something, somebody else says something back, but really people are not listening to each other because they can't parse the things that the other person says. So we say a word, there was a really, yes, exactly, a couple of days ago, implementation. That was a word that we were talking about something. And I used implementation in a different sense from some of my colleagues. And right there and then, from their reaction, I could see, okay, they are probably not thinking about the same thing I am when we are talking about this word. And so I asked, because what do you do when you see people reacting badly to what you say? Well, you pick up your gun, they pick up their gun, you go to that trench, they go to that trench, and the war begins, right? So you have to do the opposite. It's not personal, it's not necessarily something that you have done wrong or they have done wrong. No, it may be as a simple thing that as a communication mistake. And that happens every day, okay? So communication is maybe the key challenge that I face everywhere. And it's not that we don't want to communicate, it's that we can't communicate. And a computer scientist thinks completely differently from a lawyer, from an economist, and other disciplines. So at first we have to establish some common grounds, common words, common rules according to which we are going develop a project. And that is the step that I think every single one of us has to do. And that takes me back to the ego problem. That, of course, if you're somebody, a high-level policy person, or somebody really important high up in a firm, then you do not necessarily think that you have anything left to learn, or at least you don't want to show it, because, well, then I don't know something, and that may come off as not optimal. So there are all these little things, and I think they are the biggest barriers.
Can I have a very specific question of you, Olivia, with the specific example of Levente, for example, with the biometrics? How closed is the list of items in the pyramid of 4 different types of risk as of now? Because we're on the verge of enactment. Is this a closed discussion? So it's useless for him to open this up at this moment. And I have one more question about the Brussels effect afterwards.
I don't think it is really closed. So it is, and it's definitely not intended to be closed, because again, the
How
AI
much time do we have?
Well,
hope
that's
not
what,
that much, but yeah.
Yes, but we don't want, so the AI Act is not the instrument whereby we have to answer all the questions. We have to create a framework that is hopefully not wrong anywhere.
So the items will be exemplary, or they'll be logged into very high risk, mid risk, whatever risk, no risk?
Care to?
I think the terminologies are edged in already, like the levels, but
the levels
inside the levels there is still some maneuvering room, and there are still interests that that can change a few words here and there.
Is it up to the technical people, the lobbyists, the politicians? Who decides?
Well, I don't know. This is a field that is my expertise. The trialogue is where the representatives of the European Commission, the representatives of the rapporteur and the European Parliament and member states sit in the room with very few other people in the room, and they make the big decisions so that there is one joint text and can be, again, put in front of the Parliament. Mr. Boniface said that he expects that to happen, and at the beginning of next year, member states also vote on it, and then it is enacted and it becomes law, and then it has to be implemented. And I think the standardization work goes in parallel. But yes, that is the key issue, that the bucket of what is thrown into the high risk category, and then I will remind here of part of your presentation, that is where ex ante obligations are put on the providers of that technology, is open again. Is biometric fully high risk? Is generative AI fully high risk? We don't think it is, again, because it has a variety of applications that then those applications have to be tiered. And that's where it has to be drawn right. Or, for example, and it's also dynamic space. I think the other challenge surrounding the AI Act is that it happens in the midst of an extremely intense societal dialogue of AI, primarily of generative AI and large language models for the obvious reasons, but of course it will regulate a bunch of other machine learning, deep learning applications. I don't know, I came here today using Google Maps. Last week in Vilnius I translated the restaurant menu with Translate. My inbox is kept clean of spam. Those are also AI technologies. We're also going to regulate those. And I think legislators also need to, on the one hand, and this is the political analyst in me speaking, who really shouldn't in a way, but respond to political and societal pressures and demands, because law is an expression of societal concerns. And there are very current issues around LLMs in particular that keep a lot of people concerned. One other specific example is the matter of copyrighted works that may or may not be used by large language models, and those LLMs are typically trained on the information available on the open web.
Do you guys have another 60 minutes to open this part of the discussion up now?
I can wrap it up real quick. It's just another example of it's really difficult to make a balanced decision when everybody else is talking about these. But again, I think as recently as 3 years ago, the EU has adopted a massive, huge copyright reform that did create a so-called text and data mining exception. It also created right for rights holders to opt out. Actually, just last week we have enacted some further technical tools that allow web publishers to opt out by, again, technical means from crawlers that feed these LLMs. And therefore, for example, we also don't think that this should be decided right here, right now in the AI Act, which is not to say that we don't think this is an important issue. And we commit ourselves to working with a broad range of stakeholders, including publishers, in understand how LLMs and generative AI can be a tool for them and not a threat. But all this is, of course, mixed in the last stages of this regulation.
Strong statement, and the last words go to Olivia.
Oh my goodness. So yes, the copyright debate is also an interesting one. So key questions include, for instance, if whatever an AI system does, be it a large language model or something else, it qualifies as copying in the legal sense. Another one is what constitutes so-called fair use or fair dealing, depending on which jurisdiction you are. And there are a lot of trainings to lawyers to even, again, they have to understand what the system does in order to determine whether whatever they do can be classified as copying or not. So there we are, again, at the beginning of the journey. And I would just probably say that let's collaborate as much as we can. Let's try to communicate and transfer our knowledges from stakeholders between disciplines. And the more we can do that, the better results we can achieve. Thank you.
Thank you very much. And with that, we've arrived to the topic that might concern on a daily level in their works most members of the audience, AI in public service. That is, in good governance. Right after the break. Please give a big round of applause to the panelists.